Morning they fired me, I was wearing my father's watch. It's a Seiko, analog. The kind with a scratched crystal and a worn leather band that smells like machine oil, no matter how many times you clean it. He wore it every day for 31 years on the floor of a sheet metal fabrication plant outside of Columbus. When he died, my mother handed it to me in a Ziploc bag in the hospital parking lot and said, "He wanted you to have something that worked as hard as he did." I wore it to the closing table that morning because I wanted him there with me. I had been building toward that table for 4 years, not figuratively. 4 actual years of my life. Weekends, holidays, missed flights home. A Thanksgiving dinner I ate reheated alone in a hotel room in Baton Rouge while my kids called me from my sister's house to tell me what they were thankful for. My youngest said she was thankful I was safe. She was 9. She didn't say she was thankful I was there because she already knew I wouldn't be. The deal was a federal infrastructure contract, a real one, the kind that doesn't come around more than once in a career, and even then only if you spent years building the kind of credibility that makes the right people trust you in a room. The total value was $2.4 billion over 7 years. Road and bridge rehabilitation across 4 states: Ohio, Indiana, Kentucky, and West Virginia. The funding was a combination of federal highway appropriations and a specialized bonding structure that almost nobody in our division understood except me. The bonding cause, a performance and payment bond requirement tied to a multi-agency compliance threshold, was something I had spent 8 months negotiating with the Federal Contracting Office. It had to be structured a specific way, or the disbursement schedule wouldn't clear the Office of the Inspector General's review. If it didn't clear that review, the contract was void before the ink dried. I was the only person in our company who understood this completely. I had documented it. I had written a 74-page compliance brief that I updated every quarter. I had walked every senior member of our team through it, one by one, in carefully worded meetings where I tried very hard not to make anyone feel stupid. Some of them thanked me. Some of them nodded and went back to their emails. Most of them passed it to an assistant to file somewhere. My boss, I'll call him the VP, because that's what he was, read the executive summaries. He was the kind of man who had gotten where he was, through a combination of golf relationships and a talent for making other people's work sound like his own vision. He dressed well. He spoke in a measured baritone that made everything sound considered, even when it wasn't. The executive team loved him. The federal clients tolerated him because I was always standing 2 feet to his left, ready to answer the technical questions he couldn't. He knew that I knew that. I think that's what he never forgave me for. The closing was scheduled for a Tuesday in April at a federal building in Cincinnati. The attendees included a regional administrator from the Federal Highway Administration, a contracting officer from the Army Corps of Engineers who had been looped in for the bonding verification, representatives from the governor's offices of all 4 states, 3 senior officials from the Infrastructure Investment Consortium that was co-funding the project, and 2 attorneys from the OIG's office who were there solely to observe and certify the compliance documentation. There were 11 people in that room who were not from our company. 11 people who had flown in, driven in, or been assigned there by federal agencies specifically to witness this signing, and me, and the VP, and our company's general counsel, a quiet man named Richard who sat at the far end of the table and had spent the previous 6 weeks reviewing my compliance brief paragraph by paragraph. I arrived at 7:15 in the morning. The signing was scheduled for 9:00. I wanted time to check the documentation packets, verify the bonding certificates were in the right order, and make sure the compliance threshold calculations had been printed on the correct federal form version. A detail that sounds absurd until you understand that using a form version that had been superseded 3 months prior would trigger an automatic OIG flag and freeze the disbursement. I had flagged this exact issue 2 months earlier in a memo to the VP. I had confirmed the correct form version was in the packets. I had triple-checked it the night before in my hotel room. The room was set up beautifully. Long mahogany table, water pitchers, a projector displaying the project seal and the agency logos. The federal staff were professional and courteous. One of the FHWA administrators asked me about the bonding structure before the session started, and we had a 15-minute conversation that I could tell made her feel more confident about the process. She shook my hand and said, "I'm glad you're the one who put this together." I remember thinking, I should write that down somewhere. At 8:48, the VP walked in. I knew something was wrong before he reached the table. I've worked with enough people in enough high-pressure situations to recognize the specific walk of the man who has made a decision he intends to execute before he can talk himself out of it. Shoulders slightly forward, jaw set. Eye contact that lands just past your face. He stopped at the corner of the table nearest the door and asked me to step into the hallway. I said we were 12 minutes from a federal signing. He said it would only take a moment. Richard looked up from his papers. One of the state representatives glanced toward us. I set down the documentation packet I was holding and followed the VP into the hallway. He closed the door behind us. He told me that my position with the company was being eliminated, effective immediately. He said the decision had come from above him, a phrase he used as though it explained everything and required no further detail. He said there would be a severance package, that HR would be in contact, and that I should leave the building. I stood there for a moment. I want to be honest about this. I did not yell. I did not cry. I felt something settle in my chest, like a stone dropping through cold water, slow and certain, and I understood immediately that this was not about performance. This was not about budgets. This was about the fact that I had spent 4 years becoming indispensable in a way that made him feel small, and he had chosen the worst possible moment to do something about it. I asked him if he understood what was about to happen when he walked back into that room without me. He said the team could handle it. I said, with as much composure as I could manage, "Which part of the bonding clause do you want Richard to explain to the OIG attorneys?" He opened the door and went back inside. I stood in the hallway for a moment. The Seiko said 854. I took the elevator down to the lobby, sat in a chair near the entrance, and waited. I don't know exactly why. I think part of me needed to see it. Not out of spite. I want to be clear about that. I had spent 4 years on this. My father had died during year 2, and I had taken 2 days off and come back because we were in the middle of a compliance review. I had missed my son's high school graduation because of a bonding certification deadline. I had signed my divorce papers in a Kinko's in Louisville at 11 o'clock at night because I couldn't get back to Denver in time to meet with the attorney during business hours. I had given this thing everything I had. I needed to know how it ended. It took 9 minutes. I know because I was watching my father's watch. The first person out was Richard. He came through the lobby doors moving faster than I had ever seen him move, which for Richard was still not particularly fast, but his face was the color of old chalk and he was already reaching for his phone. He stopped when he saw me. He looked at me the way you look at someone when you are standing in the wreckage of something and you realize they tried to warn you. He said, "They're asking about the bonding certificate sequencing." I said, "I know." He said, "The OIG attorney flagged a form version issue." I said, "I know." He said, "The VP doesn't know what a performance bond threshold is." I said, "I know that too." Richard sat down in the chair next to me. For a long moment, neither of us said anything. Through the glass lobby doors, I could see a cluster of people in the elevator bay. A couple of the state representatives, one of the federal administrators, someone in a suit I didn't recognize. The VP was not among them. The FHWA regional administrator came out about 3 minutes later. She was not angry. That was what I remember most. She was not angry, she was tired. The specific exhaustion of someone who has done this job long enough to recognize a preventable collapse. She saw me and stopped. She said, Mr. Calloway, you're still here." I said I didn't have anywhere pressing to be. She looked at me for a long moment. Then she said, "We have a problem with the bonding documentation." I said I was aware. She said, "Is it fixable?" I said, "Yes, but not by the people in that room." There was a pause. She was choosing her words carefully, the way federal officials do when they are about to say something that is technically outside normal procedure. She said, "Would you be willing to come back upstairs as a consultant, not as a company representative? As an independent party, we would need to restructure the engagement. There would be paperwork, but the contracting officer believes we can manage it under an emergency advisory provision." I looked at her. I looked at the Seiko. I thought about my father working 31 years in a plant outside Columbus for a wage that never quite matched what he deserved. I thought about the chair in which I had sat every night for 4 years, reading compliance documents while my marriage dissolved, and my kids grew up in between my visits. I said. Let me make one phone call. I called my personal attorney, a woman I had known since law school who practiced federal contract law in D.C. I explained the situation in about 90 seconds. She said it was unusual but doable. She said she'd fax a conflict of interest waiver to the building's legal office within the hour. She said, "Did they really fire you this morning?" I said, 8:54. She said, "These people." I went back upstairs, not through the main conference room door, through a side entrance with the FHWA administrator and the contracting officer from the Army Corps, who turned out to be a soft-spoken man from Lexington named Everett, who apologized to me twice before we even sat down, as though the whole situation was somehow his fault. We worked for 3 hours. The bonding certificate sequencing issue was correctable. The correct form version existed in the original digital files I had stored in my own secure drive, and once we printed and substituted the affected pages, the OIG attorneys were satisfied. The compliance threshold calculation had been entered into the Federal Verification Portal under the wrong project classification code, a mistake made sometime in the previous 2 weeks, after I had been edged out of the final document review. That took 40 minutes to unwind through the proper federal channels. Everett handled the phone calls. I handled the documentation. By 1:15 in the afternoon, the contract was signed. 11 parties, correct forms, correct bonding structure, correct portal classification. My name was not on the signature block as a company representative. It was on the advisory engagement letter, filed as an exhibit to the main contract in the lower right corner. I went back to my hotel room, sat on the edge of the bed, and took off my father's watch. I set it on the nightstand and looked at it for a while. Later, I learned what had happened in the conference room after I left. The VP had apparently attempted to proceed with the signing at 9:02, at which point the OIG attorney had asked a single question about the bond threshold sequencing. The VP had turned to Richard. Richard had opened the compliance brief to the relevant section and started reading aloud, which is not the same thing as understanding it, and the OIG attorney had known immediately. The FHWA administrator had called a recess. 11 people had stood up and moved toward the exit, not out of anger, but out of the practiced efficiency of federal professionals who have learned to stop investing energy in a room that can no longer produce results. The VP had spent 40 minutes trying to reach people who could help him. None of them could. I found this out not from Richard, who is too professional to share internal drama, but from one of the state representatives who contacted me 2 weeks later to ask if I'd be interested in a consulting engagement on a separate project. She told me the story, the way you tell a story you have already told several times and no longer find shocking, flatly, almost cheerfully, with the slight headshake of someone who has made peace with how these things happen. In the months that followed, several things occurred. The VP's position was restructured. I don't know the specific details and I'm not interested in them. What I know is that the outcome of the April closing became a case study in what happens when you remove the person who holds the institutional knowledge right before the moment that knowledge is most needed. The executive team had questions. There were answers that required a post-mortem. I was not part of those conversations, and I didn't want to be. What I was part of was the follow-on advisory engagement that came from the FHWA Regional Administrator's Office. 3 months after Cincinnati, she brought me in as a compliance consultant on a separate federal project. Smaller, but technically complex, in the same ways I was good at. That engagement led to 2 others. By the end of the year, I had incorporated my own firm, a 3-person consultancy focused on federal infrastructure compliance and bonding structure. Our first full-year revenue was the most I had ever earned. My son called me in December. He's 22 now. He had graduated the previous June from a school in Colorado, and I had been there. Actually there, in the stands, wearing the same shirt I had bought for the occasion 3 years earlier when I thought I might make it to the previous graduation and didn't. He called in December to tell me he had gotten a job, a real one, at an engineering firm in Denver. He said, "Dad, you okay? You sound different." I said, "Different how?" He said, "I don't know, less tired." I thought about that for a while after I hung up. He was right. I was less tired. I thought about that for a while after I hung up. He was right. I was less tired, not because the work had gotten easier. If anything, running your own firm is harder than working for someone else's. But there is a particular exhaustion that comes from spending years in a place where your value is understood by everyone, except the person who decides what you're worth. When that exhaustion lifts, you don't always notice it immediately. You notice it when your kid calls and hears it in your voice. My divorce was finalized 2 years before the Cincinnati closing. My ex-wife and I are, against all reasonable probability, on decent terms. She has said to me, more than once, that she doesn't blame me for the choices I made during those years. That she understands I was trying to build something, and that the mistake wasn't the work ethic. It was the belief that the company would match it. I think she's right. I think I gave my loyalty to an institution that mistook loyalty for convenience, and I paid for it in ways that can't be fully repaid. But I still have the watch. My youngest daughter, she's 12 now, asked me last summer why I wear something so old and scratched when I could buy a new one. I told her, some things are worth keeping because of what they survived, not what they look like. She thought about it for a second and said, like you? I didn't answer right away. I looked out the window. We were sitting in the kitchen of the house I had rented after the divorce, the one with the oak tree in the backyard that drops acorns on the deck, all through October, and the afternoon light was coming through at the angle it gets in late summer, where everything looks the way things look in photographs taken years before you understood what you were photographing. I said, maybe, yeah. She went back to her book. I looked at the watch. 9:07. Analog. Still keeping perfect time. I've thought a lot about what actually happened that morning. Not the sequence of events, I have that memorized, but the deeper mechanics of it. Why it went the way it went. What made it inevitable. Here's what I keep coming back to. The VP didn't destroy the deal. He revealed what was already true. He had spent years building a position on top of work he didn't understand, and the moment he removed the person who understood it, the whole structure had nothing left to stand on. That's not bad luck. That's not a coincidence of timing. That's cause and effect operating exactly as it always does, slowly, quietly, and then all at once in a federal building in Cincinnati at 9 o'clock on a Tuesday morning. I'm not a philosopher. I'm a guy who spent 20 years learning bonding structures and compliance documentation, but I have come to believe in the most practical and unsentimental way that what you actually know and what you actually do will always matter more than the title above your name or the relationship that got you the chair. The VP had the chair. I had the knowledge, and when the moment came that required one of those things to function, only one of them showed up. That's not moral judgment. That's just how it works. The harder lesson, the one that took me longer to sit with, was about myself. I had spent 4 years being indispensable in a place that used that indispensability as a reason not to promote me, not to protect me, not to treat my time as something with value equal to my output. I let that happen. I told myself I was being patient, that the work would speak for itself, that people eventually recognize what they have. Some of them do. Some of them fire you 45 minutes before the biggest closing of your shared career because your competence has started to feel like a threat to them. The discipline I'm most grateful for, the one that got me through those 4 years and through the morning they ended, is the discipline of doing the work correctly, regardless of whether anyone is watching or rewarding it. I updated that compliance brief every quarter, not because anyone asked me to. I flew to Austin at midnight, not because I was told to. I wore my father's watch to that table, not as a performance, but because I needed to feel like the work meant something beyond a salary and a performance review. That kind of integrity doesn't always get recognized in real time. Sometimes it gets fired in a hallway at 8:48 in the morning, but it follows you. It's the thing you carry that other people can't take when they hand you a box and tell you to leave the building. Everett apologized to me twice before we even sat back down. The FHWA administrator found me in the lobby. The deal got done, correctly, completely, with my name on the advisory letter. My son said I sounded less tired. He was right. Because I wasn't carrying someone else's ceiling anymore, would I tell anyone who's been in a room like that, or is in one right now, do the work. Do it thoroughly. Document it. Understand it deeper than anyone above you thinks necessary. Not as a strategy. As a standard, the people who benefit most from your knowledge will sometimes be the last ones to admit it, and the first ones to let you go when they feel threatened by it. That will hurt. It will cost you things you can't get back. But the knowledge itself goes with you. The credibility goes with you. And eventually, not always fast, not always clean, The work finds its way back to its source. My youngest asked me why I keep wearing an old scratched watch when I could buy a new one. Some things are worth keeping because of what they survived.